Ms. Grossman, you need to unmute your mic, please.
Can you hear me now?
Yes, ma'am.
Good morning. May it please the court, Jane Grossman here on behalf of the appellant wife, Mary Hecker. Judge Lucas, I would like to reserve 5 minutes for rebuttal, please.
Yes, ma'am.
This is an appeal from a final judgment of dissolution of marriage. We have brought 3 issues to the court. The first issue is the trial court's error in determining the husband's income. The second issue is the trial court's error in determining the wife's income. And the third issue relates to the court's determination of the wife's monthly needs as it relates to alimony. It's our position that these errors cumulatively require that the final judgment be reversed, that the husband's income and the wife's income be corrected to comport with the law, and that the child support and the alimony be recalculated. The first issue that I'd like to address is the trial court's error in determining the husband's income. His experience is in human resources, and apparently he's very good at what he does. For the 9 years preceding the date of filing, the parties' combined incomes was $5.4 million, and with the husband earning all but about $50,000 of that. This gives him a rough estimate of approximately an annual income of $600,000 for the 9 years preceding the date of filing.
So Ms. Grossman, for better or for worse, I find the use of averaging and numbers and how you work with them really interesting. And I want to kind of take you to task on something, and it ties into this argument.
Sure.
It seems like what you're trying to do is take, I think it's a 9-year period, correct? That you looked at his income?
Well, that's just a preface. Ultimately, the argument and the opinion of the CPA only relied on 5 years preceding.
Okay, all right. So you've got this span of time, whether it's 5, whether it's 9, and you're taking the entirety of the dollars earned and then using figuring out the mean. You're figuring out the average, and from that you're coming up with your number. But when you look at the actual annual numbers, the distribution is kind of different, which seems to be a function of the fact that it looks like he got these stock options that he was able to collect on a couple of times, and they were big hits, but not every time. And so how should a trial court handle that? And why was the trial court incorrect here, where it seems to find that, look, this really wasn't a pattern that the law would consider in determining whether or not this was part of his income. Rather, this was, an occasional extra that he was able to get. Why not use the median instead of the mean, right? Why not figure out what is a true number where we can take care of the extra, whether it's low, whether it's high, but if there's outliers, we can push them to the sides and look at what really happens typically from year to year.
Well, I understand that position, and that's often taken in cases. It was taken by the husband's attorney in this case. The distinction, however, though, is this case is very unique. The husband and his partner, Mr. Scott, they've established a very unique, strategic business partnership. It's not like Mr. Hecker is an employee with a company, and every couple of years they have a great year and they're awarded stock options. This is a very specific business strategy, a partnership. They go into these failing or fledgling companies. They install themselves as CEO and the head of human resources. They build the company, they increase the profitability, they increase the equity with the specific expectation that this company will sell and that they will receive specific or significant stock options, for example. And I understand this hasn't happened with every single company, but for example, in this case, the company that the husband currently works for, that he went with Scott to in 2018, Devos, the husband initially wrote his employment contract so that he would earn a salary of $400,000. And after installing himself in the company, he decided a few months later that he was going to rewrite his contract. He was so optimistic that he was going to rewrite the contract so that he took $70,000 annually less in salary in exchange for stock options. And in a text message to the wife in 2018, which was introduced into evidence, he says it's going to pay out $2 million.
And it looks like it looks like he was mistaken, right? I mean, because the company doesn't have any cash.
That's what his self-serving, self-limiting testimony, not.
Well, but it was evidence. It was evidence, right?
Well, the court has to consider the evidence. He also testified that even though his employer was fine with him earning consulting income as he had during the marriage, he just simply wasn't going to do it anymore. So the purpose,
and there was no finding that he was doing that out of malice or was voluntarily underemploying himself or anything like that, right?
well, there was no testimony to the contrary that he was incapable of continuing to do what he had during the marriage. I'd like to.
Well, he testified that he's working, what, like 50, 60 hours a week at Devos. I mean, so, I mean, are you saying that the trial court reversibly erred by not imputing, without making a finding of any imputation, extra consulting work so that he should have worked more than the 50 or 60 hours that he testified that he works at Devos?
Yes, because that's the case law. I've cited case law in the brief that says if someone's working a second job voluntarily, that the trial court must consider that income. And I'd like to point out that while he was working for Devos in 2019, a full year after the dissolution of marriage action was filed, he earned almost $20,000 in consulting income while working full-time, 50-something hours per week at Devos. He just decided at trial, his testimony would be, I'm not going to do it anymore. It's too much. And the case law that we have cited in the brief specifically says if you're going to work a second job, it doesn't matter that it's over 40 hours per week or 50 hours per week. If this is your established history during the marriage, then the trial court must consider that. And going back to your question, Judge Lucas, about the stock option income, this is very unique because this is the way the husband and his partner earn income. This is the way they've decided since 2011 that they were going to earn income. Take these companies, these are capital ventures that they go in, they redo the company, and then they sell it. Secondly, this stock option income was relied upon by the family during the marriage in the years that the husband's salary may have been going up and down. There was no testimony that they took the stock option and just created a nest egg. It was uncontroverted. The CPA testified that this income was used by the parties during the marriage to establish their lifestyle and pay their bills. And it's our position that the case law requires that the trial court consider all sources of income. To be clear, we have never asked the trial court, and we are not here today to say, Judge, we would like you to take this projected $2 million and somehow include it in the formula. We understand that that would be patently contrary to the law. However, from 2011 to the present, this has been his established history, and he's good at it. And the burden should be on him that if in the future he no longer receives any stock option income, he can come into court and petition the court for a modification.
Well, I think what he would say is, look, you've identified twice in 9 years that this happened. That's not a pattern. Yes, that's our goal and it's our hope. And when it works out, it works out. But it's not a pattern. At least I think what your friend on the other side would say, it's not a pattern from which you can extrapolate a reasonable amount of money other than, to say sometimes it happens and apparently sometimes it doesn't work out.
Well, and in this case, if it doesn't, we won't know, what was it, for 4 more years, if it's going to work out or not?
Actually,
years down the road?
2020. 2018. He sent the text in 2018 that said in 4 years it will pay
So
out.
2 years from now.
Yes.
Okay.
Yes. But I have cited in the brief the Gagan case, which I'd like to cite or state the holding to the court. It says, because the stock options have been granted regularly, continuously, and have historically made up a part of the family income, some component of the stock options should have been considered by the trial court as a candidate for possible inclusion as income available to the husband.
Let me ask you this, Ms. Grossman. This was a long-term marriage, correct?
Yes.
19 years, I guess they were married?
Yes, sir.
Okay. In the 19 years of marriage, was there any evidence of stock option income to the husband making up a part of their standard of living, other than those 2 instances that you identified?
No, sir.
Okay.
No, sir. But it's significant. And as of 2018, he was optimistic enough to alter his salary compensation package and say, I'm confident enough that we're going to do this again. I'm going to take $70,000 less per year.
Mm-hmm.
So we either take the $70,000 and put it back in. Otherwise, the child support and the alimony are grossly shortchanged. Do we allow him to take his salary that he established at $400,000 per year, cut it by almost a quarter in order to get these stock options, and then just say, well, you know what? We're not going to consider any stock options. We're not going to consider any consulting income. We're not going to include any of his in-kind benefits. And that's not what the standard of living of the marriage has been. And he should not be allowed to have his alimony based upon just his bare bones salary that he voluntarily cut in order to get these future stock options. I addressed in my brief the in-kind benefits. That was totally uncontested. It was $1,725 per month, just simply ignored by the court. Never any testimony from the husband's CPA that he was no longer going to get this. This is $1,725. That is pure error that must be corrected. So it's our position that the court does, under the Chipman case and the Woodard case that we have cited to the court, have the option of averaging his income. It's permissible by law. But to simply allow him to cut his salary by $70,000 and to also ignore stock option income and consulting income shortchanges this lady who was in a 19-year marriage, and it shortchanges the child support. And this is absolutely, in our opinion, abuse of discretion that needs to be corrected. Also, there was the trial court's acceptance of, again, the husband's CPA's figure for the wife's income. The testimony was acknowledged by the husband's CPA. She was hired as an hourly employee. She gets no sick leave, no vacation. She's simply paid for the hours she works. And if she misses work, her paycheck is shorted. The husband's CPA acknowledged he erroneously took her $35 per hour, multiplied it times 40 hours, multiplied that times 52 weeks, divided it by 12, and came up with her monthly income. And he acknowledged that actually what the wife's CPA did by taking the year-to-date paycheck and looking at only the hours worked and dividing that by a monthly figure was her true income. And the error of the trial court in accepting the husband's CPA figure shortchanges the wife by $600 per month. In other words, it puts $600 per month income in her column that she simply does not earn under her specific employment structure. That is an error that must be corrected. The third issue that we raised before the court is the judge's abuse of discretion in establishing what the marital lifestyle or the wife's needs were for purposes of alimony. We've discussed the husband's ability to pay. The second component is, of course, need.
Ms.
And
Grossman, just to let you know, you're coming up into your 5 minutes.
how much time do I have?
You have you're right at 5 minutes now. You're just now touching it.
Okay. I believe that we present the argument on the monthly need very specifically in our initial brief and our reply brief. And if I don't have enough time to get to it in my rebuttal, I would like the court to rely upon that argument. Thank you.
Of course. You'll have your full 5 minutes.
Thank you.
Mr. Maros. Sir, you need to unmute your mic.
Good morning. Can you hear me now, Your Honor?
Yes, sir.
I'm Peter Maros, and I'm happy to represent the husband and the appellee, Stephen Heckert. I represented him in the trial court as well. May it please the court, I've got a lot to say and try to be as brief as I can with it. Let me put the judgment in context briefly first. This is an 8-page judgment rendered by Judge Hamilton, which I respectfully suggest is somewhat of a model of findings, with each and every finding being clearly supported by competent substantial evidence as shown in detail in her findings and in her judgment. The judgment showed a clear understanding of not only the law, but all of the facts to be applied to the law, with great logic applied to each and every issue. Each and every issue before the court was a highly fact-driven issue. And although it's always easy to say that as an appellee, in this case, it is 100% completely critical to note that there were facts to support each and every one of her rulings, and it should not be disturbed on appeal. Let me also offer that as a result of the judgment, these people and their children have survived this divorce process very nicely. The children are doing well, the one child in private school, the other child in private university, and neither party in any way has transitioned from prosperity to misfortune. To the contrary, the wife was left post-final judgment with about $1 million in assets with no debt. She was also left with her education, working in the field of her choice in a job that she chose, earning a reasonable income, in addition to which she received permanent periodic alimony, $1,200 a month in child support, $309 a month in an upward deviation of child support, $417 a month in extra expenses related to extraordinary expenses for the child, and $2,371 a month going directly towards the son's tuition, which paid 100% of the son's tuition. In addition to what she earned and her investment income, she's receiving going forward $6,602 a month. Dealing first with the husband's income, and Judge Lucas, you have pointed out a lot of this, but let me deal with some even more specifics. First of all, the judge was very specific in her findings, found on page 5, detailed specifically with regard to what she considered. It's 100% consistent with the only competent substantial evidence on that issue. That is $29,746 a month, net of $20,487 a month. There is no evidence before this court that would in any way support using historical stock options as a part of recurring income, and to have done so by the judge would definitely have been, in my humble opinion, reversible error. The only testimony on this issue, unrebutted, comes directly from the husband in a very straightforward manner, not in any way consistent with any attempt to hide any income or to in any way voluntarily limit his income. Contrary to what was stated in the beginning argument, this is a totally different job, completely different job, not some ongoing form of job consistent with prior jobs, Completely different job. Although some of the same people are involved, the job's different. He lost his prior job. Why did he lose it? Because the company sold, and his family got the benefit of a significant distribution as a result of losing that job. He's had many, many different jobs over the years. His job very reasonably went from a commission-oriented structure to post-dissolution of marriage. It actually started in August of 2018, even before the dissolution was filed. Went from completely commission structure to a job with significant salary, with a bonus that was completely accounted for in the calculations by the judge, and benefits. Prior to that, he had no medical insurance, no 401k, no paid time off, no benefits of any nature. And in his new job, he does. Was that a reasonable thing to do? Yes. 100% of his recurring income, 100% is in the judge's findings. Certainly, there's no value to these future stock options for purposes of income. I'd like to briefly comment on counsel's citing of the Chipman and the Woolard case as being support for her position that you should use these stock options to average income. And then I'm going to get into the Geoghegan case again in a minute. But not only do those cases not support that, they're totally contrary to it. Chipman reverses income that was inappropriately based on prior income and a prior job. Exactly what was looking to be done here. That reversed it. It cites Woodard, and in the Woodard case, that reversed a 4-year income averaging scenario by for the trial court, saying a 4-year average is meaningless. 4-year average, as all of the cases I've cited, it states past income, unless it reflects current reality, is meaningless and will not put bread on the table today. In addition to that, I've cited cases out of virtually every district that are 100% consistent with not averaging income. An example of how little, if any, real value that these stock options have for purposes of income is that if for purposes of equitable distribution, attached to the partial equitable distribution sheet, which is a part of the record, shows that these future stock options of Devo went in the husband's side of the ledger with no value whatsoever. Any value related to future income here is 100% completely speculative. Once again, the only evidence on this issue comes directly from the husband. The wife and her counsel could have called other people from the business, could have called this partner they referenced, but they didn't. And the only evidence is that this company currently is bleeding cash, needs cash infusions, is losing millions of dollars a year, and any hope for projection by Mr. Heckert years before, during the course of the case, or whenever, are completely meaningless as it relates to any current value of that income. It's also important to note that obviously, if some income develops in the future that was not anticipated, modification is always a possibility. But for purposes of this case, the only competent substantial evidence supports the ruling of the trial court. Counsel didn't get to standard of living, and I want to briefly comment on that because once again, it's critical. Standard of living in this case certainly is always a factor. It's a statutory factor. But not only did the judge in this case carefully consider the standard of living, she made excellent findings with regard to the standard of living that should be taken into consideration. The standard was fine, but not lavish. They equally divided all of their assets. They sold their home to reasonably downsize. This is the judge's findings, consistent with the large majority of the families in family law cases, in order to consider the ongoing major needs of these children for private school and a private university. The judge's comments were exactly what is dealt with in the cases I've cited on standard of living. that it is by no means a super factor that trumps everything. It's highly, highly factual driven, and the judge's ruling in this case was certainly in every way supported by competent and substantial evidence. I've cited 4 cases dealing with that. I wanted to briefly comment on the Geoghegan case that counsel cited for the issue that you're required to some extent consider stock options for income, and that just is not the case from Geoghegan. To the contrary, in Geoghegan, the facts are totally different. From 1995 through 2007, the husband had been continuously in the same job, and during that period of time, he had continuously received benefits related to this deferred compensation. Here, as we know, it's a different job. Only testimony, there's no value, and they weren't regular or continuous. Not only is it not reversible error to not include it, it would have been a reversible error to do so. Moving quickly to the wife's income. This is dealt with at length in the transcripts, and I want to reference the court specifically to the testimony of the forensic CPA, Mr. Berg, at pages 254 through 260. Once again, this is a question of fact. Numerous different things could have been considered, but what Mr. Berg did was not the math that they've suggested, but to the contrary, figure her actual income for 2.73 months prior to the date of the final hearing, leading right up through trial, figuring out the specific number of hours, multiplying by $35 an hour, and it's the exact number that the judge accepted and certainly consistent with competent substantial evidence. We did the math on that. That's on page 20 of our brief. So to once again make a long story short, these factually driven issues were in every respect supported by competent substantial evidence consistent with the law and should be affirmed in all respects. Thank you.
Thank you, Mr. Maros. Ms. Grossman, you have 5 minutes. Ma'am, you're still muted.
Briefly on the issue of the stock options, I would just point out that the cases we cited, the Chipman and the Woodard cases, were for the purpose of establishing clearly what the poll star is for averaging income, and that is whether it is the current economic reality of the payor spouse. That's why we cited them. And it's up to this court to decide whether or not it's his current economic reality. We suggest it has been his reality, it is his reality, and he has optimistically concluded that it will be his future reality, which is why he reduced his salary by $70,000 a year. However, sensing some resistance on the panel's part to the issue of imputing income for the stock options, I would like to offer the court an alternative for reversing on the amount of alimony awarded, and that is to have the court look at solely his 2019 income without any stock options, which is something that the CPA did. And when you do that, his gross income is $30,000 per month. He has consistently on every financial affidavit listed his salary and bonuses at $30,000 per month. When he filed for financial aid at the child's private school, he listed his income at $330,000 per month. When you take a look at his $30,000 per month compared to the wife's $5,200 per month, that's correction for the amount she actually earns, there still is a significant disparity in income. You can ignore the stock options if that's what this court chooses to do. The husband still has a superior income. Yes, he agreed to pay the private school tuition. No, it's not $24,000 a year as they've suggested. It's $1,000 per month. So if you want to adjust this $30,000 per month by $1,000 for the private school tuition, he still has approximately $28,000 per month compared to her $5,000. I'd like to finish up by making sure the court understands that the trial court made a very specific finding. In fact, she adopted the husband's proposal that the wife's monthly needs were only $7,000 per month. This figure he derived from solely looking at 6 months of post-separation expenditures. And this court, specifically in the Jeknowitz case, said, you cannot do that. And this is exactly what the trial court did. The husband's CPA acknowledged that when he was looking at the wife's post-separation income, he also just made assumptions and said, well, I don't think she needs that. I don't think she needs this. I think she might have bought that as furniture for her new apartment, and it was absolutely done without any evidence to support it. The trial court had a lifestyle analysis from the collaborative CPA, a lifestyle analysis from the wife's CPA. These were within a few $100s, and it was not disputed that during the marriage, the marital life expenses for the wife were $15,000.
It was also not disputed, though, that they were living above their means during the marriage, correct? Wasn't there evidence to that effect, that it was an artificially inflated lifestyle?
No, I do not recall that testimony anywhere. In fact, if you look at the husband's financial affidavit, every financial affidavit he files, he lists his monthly expenses at over $24,000 per month. They did not have significant credit card debt. He was able to earn good money and pay their expenses. So I would suggest to the court, if you want to ignore stock option income, look at his 2019 income. I think it's reasonable. I think it's required that you add back in the in-kind benefits. The consulting income for 2019 was $1,100 per month. It's not error to include that. And I think absolutely, based upon a 19-year marriage, that this lady deserves more than $2,300 per month. Thank you very much.
Thank you, Ms. Grossman. And we'll change up cases now and take on our last case set for today's docket, which is Synaxis Land Company et al. Versus Hunt Real Estate Services, Inc.